The Honorable Justices of the Supreme Court, hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh and give their attention to the court.
Good morning and welcome to this session of the Kansas Supreme Court. I welcome both counsel and those who are watching on the live stream. For those of you who are counting boxes, you may notice that we are short one justice. Just our newest justice, who was sworn in on Monday of this week, Justice Melissa Standridge, is recused on the case that we are hearing now. So we were sitting as a court of 6 justices. With that, I would ask Mr. Doug Shima, the clerk of the appellate court, to please call the 11 o'clock docket.
Thank you, Your Honor. May it please the court. The 11 a.m. docket for Wednesday, December 16th, 2020 consists of one case. Appeal number 118710, State of Kansas versus Jasmine DeVar Watson, Wyandotte County, briefs both sides. The appellant has reserved 3 minutes rebuttal time. Your Honor, we're ready to proceed.
Thank you, Mr. Shima. Counsel, would you please state your appearances?
May it please the court, Jennifer Roth from the Appellate Defender Office on behalf of Appellant Jasmine Watson.
May it please the court, the state appears by Deputy Solicitor General Chris Ailslager.
Thank you, counsel. Ms. Roth, you may begin.
By way of introduction, in this case, the state alleged that overlapping times on Jasmine Watson's timesheets at 2 different jobs constituted a false claim to the Medicaid program. The state charged him with that offense as well as a count of theft. The jury didn't reach a verdict on the theft count, but they did convict him of making a false claim to Medicaid. The court ordered Mr. Watson to pay just over $13,000 in restitution. In the Court of Appeals, Mr. Watson argued 4 issues. As to the 4th, the Court of Appeals vacated the restitution order, finding that the state did not prove that Mr. Watson received any money that he didn't earn. The court denied the state's petition on that point, so today we're here just on the 3 remaining issues that Mr. Watson raised. Those issues are prosecutorial error and closing argument, in which the Court of Appeals partially agreed but found no harmless error, or found the error harmless. Error in giving a responsibility of another instruction, which the Court of Appeals agreed with in part, but didn't find to be harmless, or found to be harmless error, and cumulative error, which the Court of Appeals didn't find. So although the errors have 3 different bases, they all are related in that they all involve the Court of Appeals ultimately misunderstanding or having an incomplete view of what this crime requires to be proved. So moving on to issue 1, the disagreement here is between the extent of the error in closing argument. The disagreement between Mr. Watson and the Court of Appeals is the extent of the error and whether or not it's harmless. And as I mentioned, the Court of Appeals did agree with one of the bases that Mr. Watson raised and did find that the state misstated the evidence when they said that Mr. Watson didn't produce any. Apparently, the state did not take the words coming out of Mr. Watson's mouth on the witness stand to be evidence, and the court found that to be error. But the court disagreed with the other 2 bases that Mr. Watson argued that constituted error. For example, first one, the court said that the state did not imply that simply signing the forms was the crime, and it was rather an invitation to the jury to decide whether Mr. Watson had an intent to defraud. Now, I've reread a number of times what the state said in closing argument, and I've also considered the context in which that argument came from in the trial itself, mainly by way of the cross-examination the state did of Mr. Watson, and maintain that the appellant's right. The reason is that the state's final point to the jury in its closing was, quote, how many times does an individual commit a crime and have a warning each time they do it? In these cases, they do. the state there is talking about Mr. Watson signing timesheets with a particular warning, which, as an aside, is not an accurate statement of law, is our contention. And each time he signs, he commits a crime. That's what the state was saying. And that's why we can maintain that that was, in fact, not just an invitation to the jury, but rather a misstatement of the law. The Court of Appeals also disagreed with the state's repeated comments that they were burden shifting and found them within the wide latitude afforded to prosecutors. And here's where I go back to the full context of this trial. The state's argument, obviously closing arguments, are about evidence and things that the jury heard, the exhibits they received, things like that. So the backdrop of this issue involves going back and looking at what evidence and how did the cross-examination of Mr. Watson go. And in that cross-examination, the prosecutor asked, it's all attached as part of our attachment to our petition, but I just want to highlight it today, that the questions that the state asked Mr. Watson that they then argued about in closing were, do you have any documentation here today? Are these people available to testify that they knew your schedule? Are any of those people available today? Are any of those people available today? Are any of those people available today? Have you subpoenaed those witnesses? Do you have anyone here to testify about that conversation? Are your aunt and uncle available? Is Best Choice available, etc.? This strikes appellant as sort of, I guess I could say, textbook of what not to do if you are trying to avoid burden shifting and upholding the presumption of innocence, if you will. So to me, to the appellant, you have to take the whole context into account to determine whether the state's comments in closing were burden shifting. And we believe that the context tells us that they were. So that's why we believe that the Court of Appeals was wrong in finding only one of three of the state's errors to be errors. And we'd ask this court to find all three. But even if this court were to disagree, then part of the prejudice analysis is that this court must consider all alleged indicators of prejudice. And I believe the words in Sherman are, we have leeway to argue the particulars of our case. And that those examples of what I just gave form the context, form part of the basis of why we maintain that these errors were not harmless. And we
Counsel?
also, and this,
Counsel,
yes.
excuse me. Was submission of those signed documents pecuniarily significant?
We do not believe so. In fact, that was one of the things I was going to say next, Justice Wilson, is that in making its harmlessness analysis, the Court of Appeals looked to what the actual statute that sets out the crime says, and one of the definitions that's pertinent. But the Court of Appeals makes no mention of the other definition, which is what is deception. And deception requires there to be a pecuniary, I'm trying to remember the exact words, pecuniary significance. And that is where we believe a lot of this misunderstanding between what the law requires comes from. Because Mr. Watson signing those timesheets, he testified that he worked those 4 hours. And we wouldn't be here today if his timesheet had said, I worked 4 hours on any given day. We're here because the timesheet says 8:30 to 12:30 or 1:30 to 5:30 or whatever. And so it is our contention that the time period, like the 4 hours he worked, and the state doesn't actually have any evidence to say otherwise, and that it does not make a pecuniary significance that the time 8:30 to 12:30 is what is inaccurate.
Counsel,
I don't know if that answered your question.
Counsel, is it fair for me to think of this case, this problem, in the same way I used to think about my time slips when I was in private practice, and I'd say I worked on a particular day for an hour on a case, in order to bill and make money, you know, and to bill the client and make money. Is that a fair comparison to what this is?
I'm smiling because I told my husband, I'm going to talk about my timesheets. And he said, don't do that. Because I agree with you, because I agree. The point here, and the evidence showed, and the state could not refute it, that Mr. Watson worked the 4 hours every day. It just also showed that he didn't always work them between 8:30 and 12:30.
Well,
But just as you work, sorry.
Let's take that then. If I'm billing a client back when I was in private practice and I said I worked 4 hours on Tuesday and I didn't work 4 hours on Tuesday, does the state really have to prove, does someone claiming fraud or claiming deceit have to prove that I didn't work those 4 hours on Wednesday?
Yeah, if I understand, if I'm following right, to me, it comes down to your intent to defraud, which involves a deception, which involves a pecuniary significance. And so if you billed a person for 4 hours on Tuesday and you worked for that person for 5 hours on Wednesday, then under the law, I do not believe that you had the intent to deceive. You didn't commit a deception. You might have been inaccurate. You might have, but that's not a deception.
Well,
if that answers.
And in this case, you'd have to multiply that by 270 times or whatever that is.
147, right.
It seems like you're asking the state to prove a negative. That because the defendant says I worked at some other time, that the state has to prove that didn't happen, which seems to be an impossibility.
The state has to prove that there was an intent to defraud, and an intent to defraud involves, sorry, I've got the whole statute right here. At its core, the state has to prove that Mr. Watson made a false or fraudulent statement to be used to determine a payment, and that he did so with the intent to deceive Medicaid and to induce Medicaid to rely on that, and that the falsity had pecuniary significance. I would point out, as an aside, there are 9 ways under this subsection alone to commit Medicaid fraud, and the state chose this one. I don't know if any of the other ones would have fit, but they chose this one. And the definitions tell us that there has to be an intent to defraud, which requires a deception, and a deception is not a pecuniary insignificance. And so I guess that's what the state has to prove.
Just for clarity.
Under the private.
Counsel, sorry. And I don't mean to interrupt your train of thought. You may want to go back to it, but I'm just trying to understand, what is the point of the deception if it's not pecuniary?
Ms. Roth?
Well, it's not. Oh, I'm sorry. My time's up, but do you mind if I attempt to answer that question?
No, please do answer the question.
I don't think there was a deception is my concern.
You may not want to, you may not want to concede this, but I'll just put it in the hypothetical. Hypothetically speaking, let's just assume that what the state says is true, that he didn't work the clock time that was stated on the timesheet. But you're claiming is, well, he did work the time. It just didn't happen to fall between 8:30 and 12:30 or whatever. Why was that deception necessary? Why did it happen under your theory of the case?
Oh, the testimony was that I think this is what you're mean. Mr. Watson testified that he talked to the people that he worked for at Best Choice. And if I'm remembering this correctly, they said, listen, you know, it's too hard to, whatever, as long as you work the 4 hours, it's too hard for us to change the timesheet based on whenever you're working at the Quick Trip. So just work your 4 hours. And as part of that, you always had to attach to your timesheet case notes. You would not get paid without them. And so I guess if I understand the question correctly, the reason it happened was because they just wanted him to work the 4 hours, even if the thing wasn't right, and that he got that information by talking to Best Choice.
Is it fair to say that, again, under your theory of the case, this was a pragmatic solution to cut through bureaucratic red tape, kind of like, okay, 4 hours, but we don't want to have to submit timesheets that have 8 different increments of 30 minutes each or something like that?
I think that's a good way of putting it.
It's a shortcut.
And right. And because again, our contention is there's no deception in that. It is, as you put it, a pragmatic solution, which is also how I feel about my timesheet sometime, which is what my husband told me not to talk about. But it is a pragmatic solution. And the bottom line is that the law allows a person to receive 4 hours of services a day. And Mr. Watson said he provided those, and to get paid, he would have had to attach case notes. So that's sort of the picture of how this happened and why.
And you're not alleging an insufficiency of the evidence claim. You're saying that the state's errors were prejudicial because of this understanding of what the law requires.
Right, which I realized when I was looking at McWilliams today, for example. This isn't a sufficiency issue. This isn't something that's not allowed by Medicaid. This is about, again, I go back to this idea that if Mr. Watson had just written, I worked 4 hours on January 4th, we would not even be here because he would have had the case notes and all that sort of thing. And so it's not a sufficiency. It's about what the state told the jury the law was or wasn't, what the court told, and what the Court of Appeals thought the law was or wasn't. That's the point of all this emphasis on what does the law really require.
Counsel,
Oh, go ahead, Justice Wilson.
Counsel, you agree that there were false statements made on the submission? Right.
We can't dispute, and Mr. Watson didn't dispute, that he did not always work from 8:30 to 12:30.
If the court disagrees with your position and finds that those statements do have pecuniary significance, then isn't the jury able to infer fraud such that that inference or presumption would need to be overridden or rebutted by the defendant?
Well, I guess what I would maintain is that they're not, it's not an intent, it does not, signing this form does not constitute a deception in the way that the law defines that. I admit that is an unsatisfactory answer, but I just, unless you can ask me that another, I'm sorry, I'm not sure I'm really addressing what you're getting at.
Well, I'm saying if the state presented sufficient evidence to establish there is pecuniary significance in submitting this record and expecting payment, then isn't the jury free to infer that there was an intent to defraud that would then need to be rebutted by the defendant as part of his evidence?
I guess the next thing that comes to mind is I feel like he did do that, in that he explained that he worked the time. So he didn't intend to defraud Medicaid, or he didn't intend to deceive Medicaid. He actually earned what, oh, and I also see what you're saying. I don't know. This law,
What I'm trying, excuse me, I don't mean to interrupt, but then wouldn't it be the defendant's burden to rebut the presumption?
okay, and that's where I was going to go next. So I don't read this statute as saying that there's some sort of, that there ever creates a presumption he has to rebut. So I think maybe that would be my answer. You know, the statute tells us what the elements are, and it doesn't have any sort of explicit reference to, well, if the state shows this, then he has to rebut it with that, or anything like that. And so I guess I just look at it as like a strict, these are the elements, and the evidence shows that they didn't prove all of them, but I don't read it as having, as there ever being like a explicit rebuttable presumption coming into play, I guess would be my answer.
And just real quick before we finish up, kind of piggybacking on what Justice Biles was inquiring about, what would it take for the state to meet its burden here? Would, on the day in question where your client claims 4 hours, the person that he supposedly gave the service to would have to testify, no, she didn't? Or what would the state have to do in order to meet its burden? Or would it have to be on that particular day? Could it be the next day, I provided 6 hours and not 4? How would that work for the state to, in your mind, what is the burden on the state to prove it's that element of the crime?
Well, I think that the state would have to prove that he really just did 3 hours, or he provided that service to somebody else who'd already gotten 4 of their hours. I mean, there's different ways that it could go that would violate Medicaid. And like, for example, one recipient can only receive 4 hours in a day. So let's say he said, I provided 4 hours that day, but really somebody else had done 2. Well, the state could show that, for example, or that he didn't do something at all, or that, because I was trying to think of like other ways of, well, I was trying to think of other examples. Or what if he, I don't know, somebody claimed to have done these services, but it was really somebody else. I mean, something like that. I mean, and the fact is here that the state didn't actually do any investigation at Best Choice. So I understand the court's concern, like, how is the state going to meet its burden? Doesn't that seem like it's making it kind of hard? But the fact is that in this case, they didn't actually investigate at Best Choice. The state actually explained its case as, well, it's records. This case is basically records. It's simple, it's records. They didn't talk to anybody at Best Choice that worked there. I mean, they didn't talk to recipients. They didn't do any investigation like that. And so I guess it's hard for me to feel like the state has a hard time meeting its burden when in this particular case, they didn't actually try beyond making a chart. So I'm sorry, that was a long, probably not answer to your question, Justice Rosen, but I feel like there are scenarios under which the state could prove that somebody committed under this subsection, but not under this set of facts, and certainly not in this case, given the limited investigation.
In the context of prosecutorial error, we have drawn lines between burden shifting and just pointing out the weaknesses of evidence, the lack of corroboration of evidence supporting a defense or supporting the defendant's own testimony. What makes these statements of the prosecutor fall on the side of shifting burden versus merely pointing out the lack of corroboration or the types of evidence that could have corroborated but are not before the jury in support of the defense of the defense?
Two things come to mind. First of all, the thing I already referenced, which is the backdrop to this prosecutorial error in the first place, which is the state's cross-examination of my client. The way that went down and the way that the state then argued it later in closing, to me, puts it on the side of harmful, if that's the opposite of harmlessness. It was definitely harmful when one considers the particularities of how the state conducted that cross-examination and then argued about it in closing. The second thing that is a little more tangential maybe is when I think about the error that the Court of Appeals did find, and they said that it was a misstatement of the facts when the state said that my client put on no evidence. And to me, the fact that you think that the words coming out of the mouth of somebody on the witness stand isn't evidence because he's the defendant, that seems like a pretty big error to me. And so I feel like that contributes to also falling on the side of the line that would say that this was an error that should cause a reversal of Mr. Watson's conviction.
Counsel? Sorry, Justice Wilson. My question, I guess, is, are the concepts of materiality and reliance relevant to either establishing or defending against intent to defraud, or whether or not there was a fraudulent statement to begin with?
I was not the best in contract law. So I guess I go back to the words that our statute uses in defining this crime and defining what's necessary in it. And those are things about, I guess I consider sort of materiality and this pecuniary significance along the same lines and things like that. And so I go back to the language of our statute and what is required in this offense, and think that those things, maybe they're called different words, different terms used, but that those do come into play in this crime.
I guess, in other words, if I just changed my initials on the claim submission, I don't know that would be viewed as material, and that would induce the Medicaid program to process the payment one way or the other. And is that probative of the defendant's intent? In other words, the nature or significance of the alleged misrepresentation?
I think it goes back to this idea of, I should pull out one of these timesheets, but not that I'm like going to share my screen or anything, but these timesheets, if these timesheets had just said, how many hours did you work this day? And it said 4, we would not be here. The whole reason we're here is a little bit, it's more than changing his initials, granted, but it's giving a range of times, but it's not like and so to me, it's not a material, it's not material, the time frame, it's the number of hours he worked. And it wouldn't have a case if they just said 4. And so I feel like that is a pretty good indication of why the actual range does not constitute the deception that is necessary to convict him.
Counsel, how is your argument affected if the fact finder, the jury, found your client's testimony not credible?
Well, if they didn't find it credible, then, I mean, it is, you mean it's credible about how best, okay, let me back up. If what you mean is they don't believe him that Best Choice said it was okay, I still think it's not a deception. If what you mean is they don't believe him that he actually worked those 4 hours of every single of those days, then I can't dispute. Then okay, they convicted him. But so I guess it depends on the thing that they don't believe. So there's some things where if they don't believe him, then okay, I get it, you convicted him. But if there's some things that they don't believe, like the Best Choice told him was okay, I still think it's not a deception based on the other evidence that he provided and that the state didn't.
Any other questions? Ms. Roth, would you like 30 seconds to wrap up?
I think I can just wait till it's my rebuttal time. Thank you.
All right. Thank you. Mr. Alschlager?
Thank you, Your Honor. May it please the court, Chris Alschlager on behalf of the state. Listening to all this, I almost feel like, we're arguing about the sufficiency of the evidence, but that is not the issue before the court. The issue is prosecutorial error and whether the things that the prosecutor said in closing cross the line outside the wide latitude allowed, and if so, if they were harmful. I first want to address the argument that the prosecutor misstated the law when she pointed out that the timesheets had warnings on them that said if you make a false statement here, you could be prosecuted for Medicaid fraud. The prosecutor was not stating that by signing those forms, that in and of itself established Medicaid fraud. What the prosecutor was pointing out was here's evidence of intent to defraud. That was the only issue in the case. He admitted, the defendant admitted that he made or submitted false timesheets, I think 247 times. He did not deny that he submitted false timesheets. So really the only issue was intent. Did he intend to defraud? And that's intent's a hard thing to prove because we don't know what was in his head. So you got to look to the circumstantial evidence that is there. And having a warning on each and every timesheet that says, hey, if you falsify this, you could be committing a crime and be prosecuted for Medicaid fraud is pretty good evidence of his intent. He was warned. He knew that if he submitted a fraudulent timesheet, that it would be Medicaid fraud or could be Medicaid fraud, and he did it anyway. So that was the prosecutor was pointing out that this is how you can infer his intent to defraud.
Counsel?
I'm sorry?
Excuse me, counsel, are you asking the court to find as a matter of law that these timesheets have pecuniary significance?
Well, yeah, I think they definitely have pecuniary significance because they were submitted for pay. That's how he got money from Medicaid, was by submitting the timesheets. That's why we're here. And the fact is he submitted timesheets that he admitted were false. They reported the same time that he was working, we know, at another job at Quick Trip. And of course, the implication is, because you can't be in two places at once, the implication is that he was defrauding Medicaid to essentially double dip, get paid at Quick Trip and get paid while he was get paid for Medicaid. And then when you add in the warning on the timesheets, that's just further evidence of his intent to defraud. And that makes the case there, I think, that makes the state's case. Now, he attempted to rebut the state's case, and that's what gets us into the other claim of prosecutorial misconduct, the burden shifting argument. But really all the prosecutor was saying was that, hey, we've established our case. He's claiming some innocent reasons, but he hasn't provided sufficient proof of that. And that's for the jury to decide that. And I would call attention to a couple of cases. And I think, I think the Chief Justice already pointed out that it's well settled that a prosecutor doesn't shift the burden of proof by pointing out a lack of evidence or holes in the defense case. That was State v. Williams. To get one to a more factually analogous, well, not somewhat analogous case would be State v. Duong, where the defendant was accused of molesting a little boy in a bathroom, and then he in a public bathroom. He was the only one that came out of the bathroom, but he claimed in his defense that, well, there were other people. It was a misidentification. There were other people in the bathroom. And the prosecutor said something like, well, did you identify those people? Did you describe those people? Can you describe those people? The defendant didn't have an answer. The same kind of thing here, where a defendant was kind of saying, well, I was told this was okay. And so the prosecutor said, well, do you have any documentation that says that was okay? Do you have any people that can testify to that? And of course he didn't. In my head, I kind of put it akin to raising an alibi defense and saying, I didn't do it. I was at John Smith's house. Well, then the prosecutor says, well, okay, can John Smith come in and corroborate that? That's not prosecutorial error. In fact, that's very similar to the State v. Pribble case, where essentially the prosecutor did just that, saying that, okay, you've claimed there's other people that can corroborate your story and say you weren't there. Where are they? And pointing out to the jury.
I'm sorry to interrupt, but I am trying to figure out what issue is before us. Is the question that there was prosecutorial error even reserved for our review? It appears to me that your petition only addressed the restitution issue. So is the only issue before us the question of whether those errors found by the Court of Appeals were harmless?
Yes, but the Court of Appeals only found one error harmless. When it comes to the Court of Appeals did not find error on the burden shifting argument or the alleged misstatement of the law. The Court of Appeals correctly found in both of those cases that the prosecutor did not commit error.
But on the one where they found error, we accept that as error for our review or for our consideration?
Yes, that's the, I'm sorry. That's the claim of misstating the evidence, where the prosecutor said he's presented no evidence. And that we have to concede that was error because he did testify. What the prosecutor meant, I think we can all figure out what she meant. She meant, other than him saying it, he's presented no evidence. But it didn't come out that way. She said he presented no evidence. That's wrong. He testified. He presented no corroborating evidence. He didn't present any documentary evidence. He didn't present any other witnesses, but he did testify. But I think the Court of Appeals correctly found that error was harmless when you look at the grand or the totality of the case. Let me get to. I'm sorry. I've lost my place on my notes. And there's several reasons why it was harmless. Number one, the jury was properly instructed on the elements of the crime, properly instructed that the arguments of counsel were not evidence, and that at any point where if counsel, anything said by counsel wasn't supported by the evidence, they were to ignore it. And really, as the Court of Appeals pointed out, that particular argument didn't bear on the elements of the crime so much. I mean, it was, again, undisputed that he submitted false timesheets.
Mr. Alsteiger, on the elements of the crime question, was it the state's theory below, or is it the state's argument here that whether or not the defendant worked 4 hours on any one of those given days is not relevant?
I'm not sure the state's, I wasn't involved obviously in the prosecution, and I've come into this case, very late in the game as prior counsel has moved on to other things. I think that it's not relevant in the sense that to me, it's kind of like the McWilliams case where, I remember that, I argued that case. McWilliams said he provided home health care services to the patient and billed Medicaid for it. The problem is that the patient at the time was in the hospital, and he was not allowed to bill for services while the patient was in the hospital. And his argument was, well, the hospital was understaffed and they weren't providing the services, so I went ahead and provided them to the person. And it didn't matter because it's not allowed. And so I would say, I think it's kind of the same situation here, where he's claiming that he provided services at a time that he couldn't have provided those services because he was working somewhere else. And we really have given that he claimed providing services at a time when he could not have done it, I think the implication is that there's no evidence that he provided the services. But he couldn't have provided the services because he was at Quick Trip working. And that's the crux of the case.
So it sounds to me like what you're saying is, even if everything defendant said were true, he would still be guilty.
I believe so.
But if the jury disagreed with your interpretation of the evidence and thought that he, in fact, in the aggregate, did work all the hours reported, is that a valid legal defense to Medicaid fraud?
Well, I don't know if it's a quote valid legal defense, but certainly, I mean, if he could convince the jury of that and they felt in their minds that that was sufficient, you know, the jury, you could call it jury nullification, you could call it whatever. We wouldn't know what the jury was thinking. They would simply acquit. And I would point out that in this case, the jury, well, they didn't come to a verdict on theft. That's not the same as an acquittal. They just had some kind of disagreement, and we don't know what that was, and I don't think we should read too much into that. But they certainly convicted him of the Medicaid fraud. So to the extent that he made that defense, that he actually provided the services, we can infer from the jury's verdict that they did not find that credible.
Right, I understand that argument factually, but there's, you know, hypothetically, had the jury believed that, there's nothing legally improper about arriving at that conclusion that there was no Medicaid fraud if they worked the total hours actually reported.
Well, you know, I guess it would really boil down to if the fraud, if reporting the exact times is material, I guess. Like I said, certainly a jury could, using their common sense and their, whether they had sympathy or whatever, they could come to that conclusion. I don't know that in and of itself, though, defeats the state's case. The state doesn't have to prove that he did not provide the services. We have to prove that he falsified the documents with an intent to defraud to get some pecuniary gain. And that's what we did. I mean, obviously, given the implication that he was working somewhere else, he could not have provided those services when he did. And then by pointing out that he was warned that falsifying those documents could constitute Medicaid fraud, I think there's evidence of intent to defraud. And one could just as easily come to the conclusion that his claims that he actually provided the services at a different time was just a post hoc defense that he came up with after the fact. And that's a question for the jury to decide. That's for the jury to work that out. It's not for, at this point, it's neither here nor there. That's why I said at the beginning, it sounds almost like we're arguing about the sufficiency of the evidence, but it's not really the case here. What we're looking at is, are the things that the prosecutor said, were they misconduct? And in the one case where the Court of Appeals found misconduct, was that so outside the lines and so prejudicial that it denied him a fair trial? And again, I would submit that the Court of Appeals was correct in finding that all the claimed instances of misconduct, with the exception of that one, were not misconduct or not error. And that the one case of error where the prosecutor, as I said, I mean, I think she clearly meant to say, other than his own testimony, he hadn't presented any evidence. She didn't point out that his testimony was evidence, but that in itself was not so prejudicial as to create a completely unfair trial, given the weight of the evidence. I mean, again, he admitted that he made or he submitted false timesheets. There's no dispute about that. And so it really comes down to intent. And that's, I think that the prosecutor made a valid argument that claiming that he was providing services when he was working somewhere else and doing so and signing the documents when he'd been warned that it could be fraud was evidence of intent to defraud. And so I don't think any of that is prosecutorial misconduct. And I think that renders the one instance of error harmless.
Is there a difference between pecuniary significance and pecuniary gain?
Well, I haven't thought about that. just offhand, I don't know that, you know, at least I don't know that it would make any difference in the context of this case. I mean, I suppose something could be pecuniarily significant in a larger sense, but not provide any gain for a particular defendant. But in this case, I think it's both. You know, the timesheets were significant in a pecuniary sense because that's how he was paid, and it was for his pecuniary gain. Does that answer your question at all? Are there any other questions on these issues or any of the other issues?
Can you?
I have one question. I'm sorry, Justice. All right, I'll try to make this quick. There's a sentence in the Court of Appeals opinion that bears on my earlier question. It's at the bottom of page 11 for what that's worth. And the Court of Appeals said that even if the jury believed Watson's testimony that he worked all of the hours on the day, just not at the times documented, that the inaccurate submission would still meet the elements of Medicaid fraud as charged. Do you think that was the jury's understanding of the law when they deliberated on this evidence?
Well, I think we'd have to go back and look at the jury instructions and see what they were instructed.
Well, just based on the way that this case was argued by the prosecutor.
I don't know. Just Siegel, I don't want to, I'm not trying to dodge your question, but I don't want to speculate as to what the jury thought. You know, I don't know. I would just say, look at the jury instructions, and we would presume that the jury follows their instructions, and there's no claim that the jury was instructed incorrectly on the elements of the crime. And I guess I'm not prepared to go out on that limb right now.
Fair enough.
My time is now up, so if there are no further questions, I would conclude my argument and simply ask the court to affirm the Court of Appeals and affirm the convictions.
Any further questions? Thank you. Ms. Roth, you're reserved 3 minutes.
This isn't in a very particular order, but I want to just start with what Justice Stiegel just said. And that is one of the instances that I was going to point to as an explicit statement that shows what we believe is a misunderstanding, a misapplication of what the law requires that was made by the Court of Appeals. And I suppose one could say that if the Court of Appeals believes that that's how the law works, that why would we think the jurors would think anything else? But I understand the state's point about how we can't.
On that point, if we were to think or conclude that the Court of Appeals opinion was tainted with an error of law, what would be the right remedy? Should we just correct the Court of Appeals error of law and send it all back to the Court of Appeals?
Well, I hadn't thought about it that way. I suppose you could do that because, again, our point is that at every stage in every one of the 3 remaining issues, that misunderstanding came into play when the court was evaluating harmlessness. So I guess you could send it back and have them do it. I'm thinking about an argument I saw earlier this week where my colleague also said, well, you could just sort it out too. So I guess either way, my reaction is that either way, the point is that we want somebody to decide this using the right law. So I guess that'd be my answer. The other thing, just a couple other points. I guess obviously I'm just going to rest on what I argued in my petition about issue 2. I had lots of things to say.
Can I interrupt you briefly, Ms. Roth?
Oh, sure.
I think on a dovetail of that point Justice Stiegel raised, you would agree then that if the defense of total payment, or I'm sorry, of actually working the hours submitted in the aggregate is at least a lawful defense if believed by the jury. under the Medicaid statute?
Yes, because of all of the components of the Medicaid statute and the definitions of the terms in there. Yes. And I guess I go back to the whole idea that the way this case is different from Williams, the way this case is not a falsity in the way that we mean when we talk about deceptions or pecuniary significance, is because the evidence was that Medicaid allows a person to get 4 hours of services. And so and the uncontroverted evidence, because the state didn't investigate, the uncontroverted evidence was that from my client, that he worked those 4 hours. They just weren't within the time range on his timesheet. And there wasn't anything to prove contrary to that. The state didn't investigate the case notes that he said, they didn't do anything besides compare the overlaps. And so in this instance, the falsity, as we've been calling it, was not a deception. And the uncontroverted evidence was it wasn't a deception, and it wasn't for a pecuniary significance, because he's going to get paid, and by law can get paid for those 4 hours. So,
counsel, why didn't the defendant just bring somebody from, I forget the name of the company he worked for, but some corroborating evidence? Why not do that?
If I recall correct, well, I don't exactly know, but I do recall there being some comments between the state and his defense counsel in the court about how his defense counsel saying something like, well, good and well, if we would have brought these people, there was, I think his attorney envisioned that there'd be some sort of problem with them testifying, but I can't remember what it was.
Was there evidence that there would be potential invocation of Fifth Amendment?
I think that's right. I do remember the words Fifth Amendment. I don't know why he used the word confrontation, but I remember that too. But I believe that's true, because at one point, the state and the defense attorney are talking about this place being involved in a suit, which the state was quick to say, oh no, they didn't have any fault. So it might have been, I think that's right, Justice Wall, that it had something to do with that as well. But on that, I'm sorry, I'm way out of time, but I guess just to sum up, if I may, Chief Justice Lukert, okay. I guess the state has the burden to prove all the parts of this crime, including the meaning of the words that are in that crime, as our state definitions say. They had the burden, not my client. And it was on them if they wanted to do something besides compare the overlapping times. And as I said, it was the uncontroverted evidence. There's nothing to refute that my client did in fact work those hours. And so we maintain that when the state argued that signing the papers was enough, when the Court of Appeals believes that signing the forms is enough, that is wrong, and that the errors that the Court of Appeals found and didn't find are reasons that this court should reverse my client's conviction for making a false claim to Medicaid. Thank you.
Thank you to both counsel for your arguments this morning. The court will take this appeal under advisement. We are now in recess until 1:30 this afternoon.